Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today, October 13th, is our day of conference call every other Thursday. We will first go over the questions that I have marked as frequently asked questions. And at the end of each question, I will invite follow-up questions if you have any follow-ups, no new questions. And then we will deal with the questions that are not frequently asked questions and follow the same process. Remember that these calls are not creating attorney-client relationship, as you would have heard when you logged into the call. There is a disclaimer that explains the limits of what we do here. Just keep that in mind. That's a part of this conversation. Before I get started, let me just make sure you can hear me okay. 1 second.
The conference is now in conversation mode.
Can you all hear me okay, guys?
Yes.
Okay.
Yes, I can hear you.
Thank you.
The conference is now in presentation mode.
If any of you are here for new questions, regrettably, I won't have time for new questions today. Our office forgot to, or actually Deepa was on vacation. The stand-in for Deepa forgot to lock the conference after 12 questions, which is the most I usually handle. But today we have 24 questions already. So I'm not sure we'll be able to take in new questions. First question that I've marked as a frequently asked question is, can I change my status from B1, B2, which is a visitor or a tourist status, to H1B, L1, F1, I will just add another one, green card. Can I do that? And the answer is that is always problematic. When you enter the United States on a tourist status or even a business B1 status, you are basically making a representation that I'm going for a short trip. If upon entry you try to convert to a longer status like F1, which is student, L1, H1B, or even green card, that can be found objectionable by the government, and they can say that it appears that you lied to us either when you obtained the visa or when you obtained entry into the United States. Both of these are possible points of failure. So we advise people, before you decide to convert or change status from a short-term visa like a B1, B2 to any long-term status, please discuss with lawyers your specific case. In most cases, it is not advisable, so be careful. So let's go on to the question. I have worked in the US under L1 H1B, but I've been in the US for the last 2.5 years, not working for any US-based company. Now I have a job offer from a US company, H1B is approved. I have a previous employer's H1B stamp which expired last month, and I have a B1, B2. So question is, due to the high wait time, I cannot secure a visa appointment anywhere. Can I travel to US with a B1, B2? I would strongly recommend against it, because I think that is the same problem that you are entering saying I'm going for a short trip, and then you try to convert to an already approved H1B status. I think you would do a lot better trying to get an H1B visa stamping in a third country. I know people are going to places like Singapore, Hong Kong, Maldives. Look around. Anywhere around India, you might be able to make an appointment. I definitely don't recommend going this route. Okay. *5. If there's a follow-up question on this, press *5 on your phone if you have a follow-up question. Let me go on to the next frequently asked question. Oh, there is the follow-up. Area code 646, which is New York. Okay. Let's see. Yes, go ahead, New York. Go ahead, I can hear you. 646. Okay. I am moving on. And then comes the next question. Can an H1B holder open an LLC in the US and employ their spouse on H-4 EAD? Well, this is tricky. When you are on H-4 EAD, you actually have more rights than the person who is on H-1B. Can a person on H-1B open an LLC? Sure, because they are passive. But the moment you start doing business, you could be violating your H-1B. So the smart thing would be to let your wife, if she wants to start her own business, start her own business. She can manage the business, run the business, own the business. And if you want to be a passive owner without any active participation, you can do that. But the problem with H-1Bs is that you cannot be working for any other company, including your own. So therefore, the definition of working is rather slimly against you. So pretty much anything can be work. If you're a completely passive investor, you don't even look in on the corporation, you're probably okay. But H-4 EAD has better positioning to start and own the business. Press *5 if you have a follow-up question on this. Press *5. And once again, I'm reminding people, today we will not have time for new questions. So regrettably, some things got a little messed up. Normally I take 12 questions. Today we have 24. California, I can hear you. Go ahead, please. California.
Rajiv ji, this is Amit. Thank you for answering my question. Yes, I do not have any plan to actively work on my LLC.
Right.
It's only for my wife to work because I plan to use this for investment and I want my wife to manage my investments.
I don't see any problem with that, Amit ji. One of the things you can do is, if she wants to have an LLC made, that's fine. You can provide the investment to her. If you want to own part of the company, I guess that's okay too. If you want to own majority or all of the company, that could be a little problematic because then somewhere you would be involved in managing the company as well. You should not be involved in managing. That's the way I see it. Okay?
Yes, my plan is not to engage in managing. We will have my wife and some other managing person who will be full-time employee managing it.
Yeah, that could work. Just think of it this way. Your involvement in the company should be about the same as it would be if you bought IBM stock. So if you bought IBM stock, you don't get to grab a chair and start managing IBM. Okay? So that is how much distance there should be.
Yeah.
Got it?
Yeah, shukriya Rajiv ji.
You're welcome, sir. Good luck. And then the next frequently asked question is, parents staying in or traveling to the US while their green card is pending. Well, that should not be actually a question mark. That should just be, let's just correct this while we have the time. Okay, so this is another very weird issue. So if you think about it, let's say I'm a US citizen and my mom, dad, or either mom or dad are visiting the United States and I apply for their green card. The issue of whether this is a preconceived intention and misuse of tourist visa can come up. Now, for many years, until Trump came to power, this never used to be an issue. It was understood that this is not a problem in connection with immediate relatives of US citizens. But since then, I have seen this problem come up time and time again. So I'm reluctant to just take a chance with this. I think the most important thing, if you want to apply for a green card for parents who are visiting, talk to a lawyer. It might be worth the 15 minutes it would take for somebody or 20 minutes to explain to you what the situation is and to give you good advice based upon your circumstances. It is definitely possible, but it is something that should be approached with caution. Now, how about traveling to the US while their green card is pending? Again, Technically, they should not be stopped by the Customs and Border Protection at the airport. But theoretically, at least, they can say, well, your green card is pending, turn back. So normally what I advise is if you're coming from Europe, let them do custom and immigration pre-clearance in Ireland. If they are coming from India, let them do customs and immigration pre-clearance in Abu Dhabi. That way, if they are going to be turned back, they don't have long way to go. So that's one thing to look at. But I think it is normally, I have known so many people, so many immediate relatives of US citizens, they've never had a problem. But theoretically, at least the problem exists. So it would be smart to do immigration pre-clearance somewhere closer to home. Press star 5 if you have a follow-up question. One more part of this question was, so my parents were visiting and there was a medical emergency. And let's say they took medical treatment. Is this a problem? Well, as long as there was no government funding taken, I don't see any problem. If your parents owe money to the hospital, that's the hospital's problem. That's not the government's problem. That's the way I see it. Star 5 if there's a follow-up question. No? Okay. Next frequently asked question, let's see. Volunteer work on an H1B. So I've said this before, volunteer work on H1B is perfectly okay, but make sure you're not getting any remuneration or benefits in return. So for example, let's say that I want to volunteer in the local church or temple or mosque. Is that illegal? Absolutely not. But what if they start paying me? I think then you have a problem. That is a violation of status. So if you purely volunteer and take no money for it, I don't see any problem with it. So this question here was, can I work for a startup on a volunteering basis as a technical engineer? The work is done remotely and the owner of the startup is based in Russia. And the answer is, well, if you're not getting paid for it in cash or kind, I don't see why not. Just remember one thing, have the company look into the Fair Labor Standards Act. Under the Fair Labor Standards Act, there are restrictions on free work being taken by for-profit companies. Non-profits are a different matter. For-profit companies could have a violation of labor laws if they take free work, but that of course is not your problem, that's the company's problem. Star 5 if you have a follow-up question on this. Press star 5. Okay, let's see if there's any other frequently asked question. Deportation when a permanent resident is involved in shoplifting. There was no conviction, there was a misdemeanor theft. Case can be expunged. Okay, first of all, conviction has a different definition under immigration law than under criminal law. So the definition of conviction can be wider under immigration law. So it is always better to have a one-on-one consultation. And I recommend for these cases, I recommend you speak with a lawyer who practices deportation defense in the state in which the crime occurred. Why? Because they would know the local criminal statutes. Any lawyer can study statutes, but it's probably unethical for somebody to comment about another state's laws. So there's a juxtaposition of state laws and immigration law here. It is better to consult a deportation lawyer in the state where the crime occurred. So conviction has a wider definition, number one. Number two, not all crimes make you automatically subject to problems. Also remember, the rules for deportation and the rules for denial of entry, which is called inadmissibility, are different. So if you travel outside and then you come back, it's a different set of rules, slightly different than if you are in the United States. Keep this in mind. And the next thing you keep in mind, as I was saying, was not every crime is automatically a problem. So if you have, for example, a misdemeanor, which typically tends to be the lesser crime, unless you have sentence imposed of 6 months or more, I think you should not have any issue, especially if the Crime is not of moral turpitude. That's another term that you need to worry about. All in all, these cases don't worry me as much because most of this looks like a minor offense, but I would not want to take a step further without consulting, as I said, a deportation defense counsel in the state in which the crime occurred. Also remember, expungement has no meaning under immigration law. Even if your record gets expunged, if there is ever a question, have you ever been arrested? You have to say yes, because the expungement under immigration law has no meaning. *5 if you have a follow-up question. Press *5. Okay. Let's see. Here's another one. 7th year H1B extension with pending PERM. Okay. My H1B max out is January of next year, 2023. PERM started in September 2021. Prevailing wage for the 7th year extension of H1B is so they want to know, when does the 1 year after which you can get H1 extension begin? Is it from the date we file the PERM, in this case August 2022, or the date on which the prevailing wage is filed? So the answer is when you actually file the PERM application, August 2022. So you become eligible for 1 year extension in August 2023. Between January and August, you would not have a status to work unless you have some recapture time left. Of course, if your PERM gets approved and your I-140 gets approved, you can immediately get 3-year H-1B extension. Okay. *5 if you have a follow-up question on this. Press *5. All right, we are done with these. I think these are all the frequently asked questions we had. Yeah, so let's now begin with the regular questions. This is question number 5. My daughter is past 21 years of age and is working on H-1B visa. She has 2 485s filed as my dependent. Can her company start a new green card for her? Will it affect the pending 485s? Yes and no. So she can start a new green card, no problem, and it does not affect her pending 485s. Go for it. *5 if you have a follow-up question. No issue at all, sir. She can go ahead. Next question, number 6. Attorney from India, currently on H4 trying to pursue bar exam. Okay. I'm not eligible for H-4 EAD. I was an attorney in India. I have spoken to the state bar. I'm eligible to appear. I'm concerned about the below questions. Can I give the bar exam on H-4 visa? Yes, absolutely. Can I appear for MPRE? Yes. Can I appear for moral character determination? Yes. If I can do all of the above, can I take an oath to be licensed as an attorney? Yes. Can I also do minimum continuing legal education and new attorney training on H-4? Yes. I don't see any problem with any of this. By the way, when I took my bar exam, I was on student status. When I passed the bar exam, of course, I was still on student status, and I started my first job on OPT. Okay, so there's nothing wrong with this. This is perfectly fine. *5 if you have a follow-up question on this. Press *5. Can I switch jobs after getting green card? This is question number 7. I have completed 6 months from AOS filing. So we have covered this in our frequently asked questions. Is it safe to change after 3-4 months of getting the green card? Do I need to take a letter from employer? See, the way I see it is, and you should listen to our frequently asked questions. I won't do any more details than what I'm telling you right now. I feel that as long as you had no intention to change jobs, when you filed the 485 and on the date your 485 was approved, If something happens that is much more attractive job offer or better working conditions, I think you're justified in changing jobs. That's the way I see it. Okay. Star 5, if there's a follow-up question. I don't think you need any letters or anything. Okay, here's a follow-up question. Area code 646, New York. Okay. Yes, go ahead, New York. I can hear you.
Hi, Rajiv. Thanks for hosting this call. This is very helpful.
Absolutely.
I've completed. I received my green card approval on July 2nd.
Right.
This year. So July 2nd this year.
Right.
Which means I've completed almost 4 months.
Right.
And I already have listened to the video you have made on the subject. So I will I will ask a very specific question to my case.
Go ahead.
So I have a autistic son who is taking disability services in New York.
Right.
And moving to some other state.
Right.
To impact those services.
Right.
So if my employer is not able to give me a job in New York,
right.
will that be a valid reason for me to change jobs?
I would argue that it is. Because these are conditions that make it possible for you to only stay in New York and work. And if they can't find you a job in New York, I think you're justified in leaving. That would be my argument. Okay?
Great. Thank you, sir.
You're welcome. Good luck. And good luck with the baby.
Thank you.
Okay. Next question. Got divorced while asylum case is pending. Sir, Taranji, I have no idea about asylum cases. You want to talk with somebody who does asylum. We don't. Next question. Let's see. H1B cap exempt issues. Oh, this is a very long fact pattern. Not sure I have the bandwidth here to go through everything, but I'll answer the broad questions. I have 2 approved H1Bs, cap exempt and a cap subject H1B. Planning not to initiate it, which I guess you mean 2 approved H1Bs. So the H1B that was cap subject has been approved recently. Got it. Planning not to initialize it. I'm working full-time for a cap exempt company. Okay. Now filing a new petition for concurrent H1B using renewed approval notice of cap exempt H1B. I have a Dropbox appointment. Not entirely clear, but what I understand you to say is that you have a cap exempt H1B. You also got a cap H1B concurrently, and you will be traveling to India. Is it okay to travel to India while an expired concurrent H1B petition and a new concurrent H1B petition are pending? I don't see any problem with that. Will I face any issues during the cap exempt extension stamping? I don't think so. That's your choice whether you want to initiate the concurrent H1B or not. Will they ask anything about concurrent H1B? If they do, you respond truthfully. That's how it should be. And why I filed concurrent H1B instead of cap H1B? That's totally your choice. I don't see any reason why you need to worry about that. What will happen to cap approved H1B if I don't transfer to or initiate it after return from India? So I think we have covered this in our frequently asked questions. Employers should revoke the H1B because they shouldn't leave the H1Bs active forever. But if you have not changed status or gotten a visa stamp, they could potentially keep the H1B going. I would never recommend it to an employer. Okay. I have approved I-140 from cap exempt and past 180 days. Planning to switch to employer XYZ after coming back. Can I still file for H-4 EAD for my wife? So if your I-140 stays approved for 180 days, which it did, then if you get an H1 and H4 through another employer, that benefit of the 180 days should pass on and your wife should be able to get H-4 EAD. Okay. There are too many other issues. Should I include the concurrent H1B in DS 160? Only if the question is asked, because you are not really activating that. In other words, you're not getting a visa stamping. So I'm going to skip those couple of questions in between. Star 5, if you have a follow-up on this, press star 5. Okay. Green card and re-entry permit, question number 11. From India, came on B1, B2, converted to F1, filed for investor visa, I-485 got approved, got conditional green card. So your lawyers are saying if you are leaving for more than 3 months, apply for a re-entry permit. I tend to agree with them. I would say if it is less than 6 months exit from USA, I wouldn't worry about re-entry permit, especially if you are not getting rid of your apartment or your house and you're not quitting your job in the United States and taking up a job in India. If you are leaving for a less than 6 month trip, I would not probably file a re-entry. But if I were leaving for more than 6 months, I would definitely file a re-entry. Star 5, if you have a follow-up question. Star 5. Okay, let's go on to the next question. What happens to the US visa when a passport is renewed? So let's say I have my old passport and my new passport, and my visa is in my old passport. So what you do is you will carry both passports, because the old passport will be returned to you with a corner cut off or some such device that Indian government typically uses. But there's nothing wrong with using the visa stamped on that passport. You cannot update a passport. You have to apply for it all over again. But you can carry the two passports together. Okay. Star 5 if you have a follow-up question. All right. Let's go on to the next one. Can a US citizen expedite immigration process for mother on humanitarian grounds? Extremely unlikely. Extremely unlikely. Does her employment shows ties? So visitor visa, yeah, of course. You can try getting a visitor visa. There's nothing in the law that stops you or her from applying for a visitor's visa. Would she be given it because the green card is pending? There is a good chance she might be, because like I have said earlier during this call, I know many people who've got their tourist visas and tourist visa entries even while their green cards were pending, because they are immediate relatives of US citizens. Okay? And you can cancel your father's petition. That's a good idea. Star 5 if you have a follow-up question. Star 5. Okay, this one is from area code 346. I don't know where it is from. Okay. Where are you calling from? 346. Hello.
Hi.
Where are you calling?
Can you hear me, Rajiv, sir?
I can hear you, sir. Where are you calling from?
Yeah, I'm calling from Texas.
Okay, Texas. Go ahead, please.
Yes. So now while filing for the petition, my mother was in one address. Now she's thinking of moving to a different address. So what is the procedure for us to go ahead and change that?
But this is an address in India, right? Not in USA.
Correct.
Yeah, that's right now. You don't need to do anything.
Should we change the?
No. Right now you don't need to do anything, but you can. You can actually open a service request and tell them to change her address in the forms. Although it is not required, you can do it at the next step, which is NVC, National Visa Center.
Okay. Got it. And you're saying that while the immigration is under process, my mother can apply for a visit visa.
Absolutely. Go for it. But just remember, answer all questions truthfully, including the fact that the green card is pending. Okay?
Yes, definitely.
Right.
And And, I'm understanding that, if she has to immigrate here, she has to give up her government job. That's correct?
Absolutely.
She cannot keep the government job.
And that's a question of Indian laws. I don't see how she can.
Right.
Okay.
Otherwise, the police clearance, she may not get it, correct?
I do not know exactly what the Indian rules are on this. I can tell you this, that the police clearance is required. But it is my understanding that you have to resign your government jobs.
Okay.
All right.
All right, sir. Thank you so much.
Good luck. Okay, go on to, that was a frequently asked question. We did that. So traveling outside the US, this is question number 16. Traveling outside the US while I-131 is pending and change of address when a green card application is pending. I filed I-485 for myself and family, received the fingerprint request. Now I have to travel out of the US urgently for 3 weeks. Can I travel out of the US after my fingerprints? Yeah, because if you travel while your I-131 is pending, you will have to come back and file it again. Because if you have a valid H-1B visa on your passport, you can travel, no problem. But come back and refile the I-131. While my I-485 is pending and my citizenship is changed from Indian to Canadian, do I need to inform USCIS? No, you do not. Just any further paperwork you file and there is a question about citizenship, you will indicate that you are a Canadian citizen. So whenever you file the application, the information has to be correct as of that date. And if after that the information changes, it's not a problem. I don't see this as an issue. *5 if you have a follow-up question. *5. Okay, there is a follow-up question from area code 848, New Jersey. Yeah, New Jersey, go ahead, please.
Yeah, this was my question. So we can travel outside the U.S. with a valid H1B and H4 and
visa. There should be a visa.
Back. You said we'll have to.
Yeah.
Yeah. There is a visa stamped in the passport.
Good. You can travel. When you come back, just refile the I-131. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Next question is number 17. Can a pregnant student, F1 student, drop their course load? Yes, absolutely. If you have a doctor's note, you can talk with your DSO. Medical exemptions are given all the time. That can happen. *5 if you have a follow-up question. All right. Next question, number 18. I-797 approval with different employer name in spouse's visa stamp. Well, spouse is on H4. If she has a different employer name, that should not affect you at all. Nor should it affect the H-4 EAD. I wouldn't worry about it. I don't see this as a problem. *5 if you have a follow-up question. Okay. Next question is number 19. Entered USA on H-4 visa. The stamp is missing on passport. So entry stamp is missing. Well, I would focus on the I-94. Okay, that's number 1. Number 2, the Customs and Border Protection has an email address for I-94 correction. You can send them an email and they're very quick in responding. I got a response from them within half an hour. So send them an email that I don't have an entry stamp. Is this a problem? Other people have reported the same issue, but normally when they have that issue, they also don't have an I-94. So make sure that you have an I-94 that you can download and it's recent and current. Then if you don't even have an entry stamp, I'm not that concerned. But send an email to the CBP anyway. *5 if you have a follow-up question. All right. How long does it take to get a consular appointment date in Mumbai after NVC approved? Nobody knows. Nobody knows. Sorry, I can't help you there. It's a few months now. What does that mean? I can't really tell you. Can I work remotely on L1B visa? What documents are required at the port? I'm an Indian citizen and currently working in USA on an L1B visa. Can I travel back to India for 2.5 months and work remotely from there? Sure, why not? So you are working on the US job from India. That's perfectly legal. What documents will be needed at the port of entry besides passport? I don't see any problem. You could probably have a copy of your pay stubs showing that you've been getting paid by the company. That should take care of it. Maybe even a support letter that explains your job situation and that there is continuity of L1. They're not letting go of the L1. They are still keeping it. That should take care of it. Star 5 if you have a follow-up question on this. Okay. Question number 22. Can I get my current H1B and H1B extension stamped at the same time? Can the spouse get the current H4 and new H4 visa stamped? My current H1B and my spouse's H4 expires in Feb. I have my H1B extension approved starting March. We don't have a visa stamp for our current visa. So basically, you want to know if they will stamp you all the way to till the extension, and the answer is there is a time limit. I believe they can do it, and this is a guess, I don't remember the exact time limit. I believe they can do it within 4 months of the expiration of the current status. Okay, something like that. You can double check with the consulate. Not a bad idea to email them. I think that should take care of it. So there's a time limit. They can't do it like 1 year ahead of time, or 8 months ahead of time, or 6 months ahead of time. They have a time limit. Okay. Oh, I think this was the last question. Wow. That went through very quickly. Anybody has any questions? Actually, most people have logged out because they realized we didn't have time for new questions today. But anybody has any other questions? Press star 5. Looks like we are good. Okay, good talking with all of you. This went by a lot quicker than I had anticipated. I hope I've covered all the questions. Yep, I did. Very good, folks. Always a pleasure talking to you. Take care. Bye-bye.